Hey there, and welcome to RAFF 6205. This is week one of Summer A 2020, and I'm so excited to be with you. I'm Chet Barclay, and I'm your instructor, and I hope you enjoy taking this course as much as I have enjoyed teaching previous courses, and as much as I look forward to being with you the rest of this very short semester. Today we're going to take a little time for introductions. Then I want to talk about our two subject areas for the day, and that's FDA inspections and FDA administrative sanctions. I'll have about 25 or 30 slides, so we may be together for 15 or 20 minutes, even a little longer. But I want to get into some orientation kind of things, and let's get into our slides, and then I'll be back on camera before we leave. In terms of welcoming remarks, I've already put my personal introduction in Blackboard in the discussion board tab. I am a former Florida attorney. I resigned from the Florida bar about 2 years ago, and while I was practicing, I represented healthcare providers in a wide variety of licensing and other kinds of administrative and court cases, and even did some FDA-related work for clients. My experience includes work on administrative hearings and in state and federal courts and in state and federal appeals. So the reason I give you that little bit of a background is to try to make you comfortable with my involvement in the course, and to ask you to, when you do your personal introduction for the Blackboard, to tell us a little bit about yourself, including, because it's a law-related course, the state and federal trial and appellate courts that govern where you live. And then you want to share your information on Blackboard, and then interact with a couple of other students. As you do your introductions, which are due week one, you need to start beginning to work on selecting the FDA meeting that you would like to attend. You can do it virtually on the internet, or if you're in an area where the FDA is holding a meeting in your area, you can certainly go there. And if attending a meeting is not feasible for you, then get in touch with me and let's work out a rule that you will monitor for a few weeks, and then you can report on either of those activities later in the course. But you need to start thinking about what meeting you would like to go to, and if that's not feasible, what rule you would choose. And then further on, week number 3, the topic of your paper that's described in the syllabus needs to be identified by week number 3. As you select a topic, my strong suggestion is that you make it narrow enough for you to cover thoroughly. After all, our time is limited in this course. So that's my orientation for you. And I just want to go up to 40,000 feet and look down at the FDA. And when we look at it, we need to remember that it's responsible for about 25% of the American economy. And in doing so, that economy is subject to more than 500 pages of statutes and over 4,000 pages of rules. And that's an enormous amount of statutory and rule law. And in addition to that, in addition to the statutes and the rules, there are thousands of administrative hearings and hundreds of court cases. And my point is that you and I can't cover all of 500 pages of laws and 4,000 pages of rules and the administrative hearings and the courts in the time that we have. So we've reached a different kind of approach here. What we want to focus on are the regulatory aspects, the quality and the compliance approach as we study the FDA. And I've tried to narrow it down into manageable goals. What you and I want to focus on is the materials in this course that involve compliance issues and strategies. And if you will be attentive to the material in the discussion boards and in the weekly sessions, you'll get your way through this course comfortably. At least I hope so. So let's take a look at the FDA overview just for a moment. Got more than 15,000 employees all over the country, but the bulk of them are up in the northeastern part of the country in the DC area. And you already know, because you, like I, are watching the weekly briefings on the coronavirus, and the FDA has taken the lead and has done an excellent job of burnishing its already really good reputation by its prompt and effective work in the coronavirus efforts. Now we're going to talk a little bit about the FDA statute, and what it does is defines certain prohibited acts. And then to address those prohibited acts, it has statutory authority to seize products, to enjoin, meaning prevent people from taking action, and it has authority to prosecute violators, those who violate the FDA laws. The FDA's business is not so much seizing, enjoining, and prosecuting as it is seeking voluntary compliance. In fact, FDA compliance is a paramount and overriding and overreaching and overarching goal, not only for FDA, but for the industry and the consumers. Frankly, the last thing that you and I want to be involved in, if we're in the industry, is in a fight with the FDA. They are excellent at what they do. They're well staffed, they're well funded, and can be very assertive in their positions. So you'll hear me say as we go through this course that FDA compliance is our goal. And you'll hear me ask you again and again, what are your compliance issues and your strategies for being in compliance? Now, one of the ways and one of the first lines of regulatory actions has to do with FDA inspections. So I thought it would be helpful in this first week to outline for you the types of inspections and just a word or two about them. First is the pre-approval inspections, and these will occur in several different categories of marketing applications. And FDA uses its inspections as its primary method of identifying regulatory violations, to be frank with you. They also use inspections to actually learn from us in industry what the current trends are, and also to spot what's up with manufacturing or testing issues. It also provides the FDA an opportunity to explain face-to-face how it believes generalized regulations apply to your specific sector. So one of the types is the pre-approval inspection, and another inspection are the routine ones. And these will either be routine based on a time schedule or on a risk basis. And what the risk basis means, if you're involved with a risky product or it's a risky manufacturing or development process, you'll probably get inspected more often or more frequently just because of the risk. But there's pre-approval, routine, and then for-cause inspections. And these are often the most problematic because they've more than likely been generated by a complaint either from an employee or a competitor or a consumer. Now, inspections play an absolutely prominent and key role in almost every warning letter and injunction proceeding that you're going to be looking at as we go through this course. Now, if there's an international issue involved, there are international inspections, and those are trending away from on-site and personal inspections toward simply reviewing the inspection reports of foreign countries. So after inspections, there's some potential outcomes. Some are good and some are not so good. So let's take a look at them. Our goal in the industry, at all costs, we want to avoid issuance of what's called a Form FDA 483. And we want to avoid receiving a warning letter because both of those are separate outcomes, but they initiate more formality afterwards. So we don't want to get into formalities. We want to keep on a friendly basis with the FDA as we can. So our goal is to avoid getting a 483 and a warning letter. And as we go through inspections, what we will want to be doing is making minor corrections showing the FDA inspector that we're committed to compliance. And that's got to be an absolute, true commitment from the highest levels of our organization all the way down. We don't want to be fooling around with FDA inspectors. We want to demonstrate our commitment to compliance. That 483 that I mentioned will detail the observations, and these will be critical observations that earned a mention and issuance of a formal document. Then there's a warning letter, which is a little bit less threatening than the 483, but both of them still require further efforts. And the outcomes get worse as we talk longer about them because after an inspection, the FDA might initiate a seizure action or an injunction proceeding or a civil proceeding or a criminal proceeding. So the longer it hangs in there, the worse things can become. And if it's an international issue, an import alert will be issued and products can be detained without physical examination. If you haven't been wondering, you ought to be wondering, what is the FDA's inspection authority and what kinds of facilities can it inspect? Well, it's got broad authority to inspect within reasonable limits equipment, materials, containers, and labeling. And it can look at finished and unfinished goods under the statute that I've quoted here, and it has separate authority to access records. Having somebody come on site and look at records almost always brings up the notion about hard timing or stonewalling and refusing access to FDA requested materials. Do not do that, because if you refuse access and do it incorrectly, you're looking at civil and criminal sanctions squarely in the eye. You don't want to be involved in refusing to permit access to or copying of certain records. And you don't want to be involved in refusing to permit FDA to enter and inspect your facilities. And I say all these things, and I would say them that all of these actions need to be addressed beforehand with competent counsel, so that you're saying the right things at the right times and you're not taking a foolish stand. In fact, if you fail to keep certain records and make certain reports to the agency, that's going to, in and of itself, provoke a 483 or civil or criminal sanctions. I've included in your Blackboard materials in the week 1 weekly session a guidance from the FDA on refusal to permit access, and I commend it to your careful study because it will be helpful to you as you work with the FDA in your career. Now, going further, we're talking about having an FDA inspector on the premises. What if the FDA wants to talk with our employees? Well, they certainly have the authority to do so, and in fact, except for biologic product manufacturing, there's no specific authority to interview company employees, but there's no ban against it except in the category that I've put for you in this administrative rule in Chapter 21 of the Code of Federal Regulations. But because we know that the FDA will want to talk to us, we need to anticipate that and have a company policy with respect to interviews, whether or not that we're going to allow it, and if so, under what conditions, whether or not we're going to require them in the presence of company counsel, which is strongly suggested, what we want to be in. Our goal here is we don't want to be involved in gamesmanship to refuse or delay an inspection. And there's about 5 reasons, and I've put them on this slide. And you notice I didn't animate these bullet points because I want you to be looking at them as we talk about them. If we're going to play games, the FTC knows how to play games also, but it holds many of the trump cards because the FTC Act makes criminal a delay, denial, or limitation of an inspection. And if you delay, if you're in drugs and you delay, the FDA may say that those drugs are deemed adulterated. And again, look at the guidance of 2014 about defining the definitions of delaying, denying, or limiting an inspection. And there's an example there that even refusing to permit photographs by a FDA inspector is probably going to be equivalent to a refusal or limitation of the inspection, absent a reasonable explanation, maybe like a camera flash that might negatively impact product quality. So gamesmanship, in my judgment, ought to be off the table for us when we deal with the FDA. There are more appropriate areas where gamesmanship is a proper thing to get involved in, but not with the FDA or other oversight agencies. So what do we do and how do we get prepared for an inspection? Well, one of the first things we need to do is get out the results of our last inspection. Take a look at any outstanding deficiencies or observations and make sure that they've been addressed and resolved, and if not, their current status and a timetable. You don't want to start off the inspection. The inspector already knows what the last inspection says, so that's liable to be the jumping off point of this inspection. So get off on a good foot and say that every deficiency has been cleared up and every observation has been cured. The last thing we want to have happen here is a repeat of the same deficiency or observation, so that we're not seen as being obstreperous. If there's any outstanding customer or user complaints, or any of those are outstanding, clear them up before the inspection. And you want to know what the corrective action or preventive action statuses are. I think even more important than these are to pre-prepare yourself by keeping apprised of recent developments in FDA law and regulatory policy. And taking this course is an excellent first step in achieving this last bullet point. What we want to do in preparation is to have on hand specific standard operating procedures, not only for the FDA, but for other governmental inspections. And when we come up with those procedures, we want to train our employees. We want to make sure that we define the roles of our company employees, like the Director of Regulatory Affairs, the Quality Assurance Manager, and the Production Manager, so they know their roles in the inspection. And we want to make sure that with respect to the FDA, that there's one individual primary point of contact. I'm a bug on training, and I believe that formal training on the company's policies is vital. And I think even consistent with that training is the notion of having one or two mock FDA inspections every year. There's no reason why you shouldn't go through a mock inspection at least twice a year, because it may be even tougher than the actual FDA inspection. And then consider conducting a formal risk analysis and have that in your pocket if the FDA asks for it. Another point about being apprised of recent developments, if we haven't done that, if we're talking to the FDA about outdated policies and outdated statutes, and we're not up to date on FDA laws and rules, they may take that alone as the cause of a negative inspectional observation. You can expect in an inspection questions and answers from the inspector. So at the end of each day, I recommend that you hold a mini closeout meeting of the day's inspection and be prepared to answer questions posed by the inspector. And then you want to document the FDA's questions and requests and make notes of whatever documents and materials were reviewed or samples taken. And then you want to summarize each day's inspections, because you're going to need them when the closeout meeting occurs. Now, closeout meetings will involve a discussion with the inspector of any violations or observations, and there'll be some discussion of relevant corrective actions. And if there were significant violations observed, the Form 483 will detail those. And then following the closeout meeting, there'll be an establishment inspection report after every inspection, and that will summarize the inspection and the agency's observations. So that's a thumbnail of an overview of the FDA and its inspections. And now I want to spend a little time on talking about selected FDA administrative actions. And I've put on this opening slide a helpful source for you, and that's the FDA's Regulatory Procedural Manual. I've got a link to that in your Blackboard materials, and I'm not going to go through point by point these selected actions because I'm going to be mentioning some of them in a little bit of detail before we go. But I just want your eye to go down these so that you're getting familiar with some of the quivers in the FDA's some of the arrows, in the FDA's administrative action quiver. So let's take a look at one of the first of them, and that's a warning letter. And that's not as serious as a Form 483, but what it'll do is it will document violations that became apparent during the inspection or the investigation, and they're usually involved with processing, adulteration, or insanitary conditions and they're situations that they're regulatorily significant, but for which they want to seek voluntary compliance. And there's a response process to that. And I want to point out to you an important weapon that the FDA has in its quiver, and that is that much of what it does is posted for the public. The FDA is superb at using the public media and publicity to get work done and create a positive atmosphere in its behalf. Nothing is more frightening to an industry executive than seeing headlines in the paper above the fold about some kind of an FDA press release or a press conference or in the 6 o'clock news involving your company. So it's a very effective enforcement tool. Untitled letters are a little less domineering than warning letters. They're an informal notice of violation, and some of them are posted. Recalls are mostly voluntary. There are instances where the FDA can enter a mandatory recall, but most are voluntary, and they involve a notice to the FDA, which would include the circumstances surrounding the situation and the corrective action. And there's 3 classes of recalls, and they are increasing or decreasing in severity. Class 1, they all have to do with the probability of serious adverse consequences or death. The lowest class is unlikely. The middle class is it's possible, and the highest class is class 1, a reasonable probability of serious adverse consequences or death. Note that failure to comply with a recall is an FDA prohibited act. And there it again, you're going to see this time and time again in our slides. The public is notified. If it involves international goods, what may happen is a detention is put on the importation of that product because imported goods must meet U.S. standards. So if they don't, entry will be refused, but reconditioning is allowed if possible. And again, the public is going to be notified. There's an administrative detention where the FDA can hold, at least temporarily, adulterated or misbranded food, devices, or drugs. In the case of food, it can be 20 days. For devices and drugs, for 30 days. There is a clinical hold having to do with clinical investigations. And if something goes awry in an inspection, a clinical hold may be imposed. And what that does is it delays the proposed investigation or the ongoing investigation, and subjects are not to be given the investigational drug. Now, one of my favorite administrative sanctions has to do with the FDA's application veracity policy. What this involves is when the FDA sees a pattern or a practice of wrongful conduct by industry that raises significant questions about the reliability of our information in our application, or it sees that it's a fraudulent application, or there's been a bribe or an illegal gratuity, or there's a false statement or unreliable data, further application processing is going to be suspended pending resolution of the issue. I'm a strong supporter of that policy because nothing is more harmful to you and I in industry than an unscrupulous competitor lying, bribing, paying off, and using unreliable data in its efforts. It tarnishes that provider and it tarnishes unnecessarily our industry. One of the most powerful weapons of the FDA are civil money penalties. We'll study them in more detail later, but they always result after administrative or judicial proceedings that involve due process of law, such as notice of the issue, the right to a hearing, the right to confront witnesses, the right to present evidence, and a right to appeal. Now, civil money penalties range from pocket change, such as hundreds of dollars, to millions of dollars per violation. And the sanctions get more serious as we go. It can be debarment, which precludes an individual from working in the drug industry, and that happens if there are specified misdemeanor or felony convictions. And I want to conclude the substance of our time together today by mentioning this strong and powerful aspect of publicity. And among the publicity venues that the FDA uses are the Federal Register. That is a daily publication of federal activity, and you should be looking, or someone in your organization should be looking at the Federal Register every day to see what the FDA is up to, because the FDA is excellent about announcing, for the most part, its plans and intentions for the upcoming period of time. In addition to the Federal Register, the FDA is expert at media press releases, press conferences, commercials, blogs, and it operates a robust website that is a treasure trove of information for you. If you haven't explored the FDA website, do so as soon as practicable. It is an enormous help to you with regard to your FDA career and this course. So, that's an overview for week 1. And let me just suggest 3 possible compliance strategy takeaways. Number 1, make it your strategy to be proactive, to take steps to be and remain in compliance. You want to have, for example, procedures to review labels, and you want to cooperate with voluntary recalls. And then finally, you want to be aware of FDA statutes, rules, and guidances. And you've already, by listening to this lecture and looking at the materials for week number 1 in Blackboard, you're already becoming aware of some of their statutes, some of their rules, and at least one of their guidances. Now, next week, we're going to take a look at FDA civil and criminal enforcement. And I want to remind you that you need to come up with your FDA meeting that you're going to attend, either actually or virtually. And if that's not feasible, get in touch with me and let's talk about a rule that you would like to explore. And that's due in week number 2. At the end of week number 3, I'll be looking to see what topic you've chosen to write a paper about. Now that topic needs to be really narrow to be sure that you can cover it thoroughly. It's been a joy to be with you today, and I look forward to being with you again next week, and I'll see you then.